It took no time at all for the justices to start their questions. Justice Thomas started off with a question about precedent.
What do you do with respondents' argument that this is merely an application of our precedents?
I don't think it is an application of this court's precedents, Your Honor. And Justice Thomas, it's because this court's precedents in McDonnell-Douglas lays out a framework, and then McDonnell versus Santa Fe Trail says they apply to the same terms and same standards. But the background circumstances rule isn't the same term. It's not the same standard. The Sixth Circuit says it's an additional burden. And in prior cases, it says it's a difficult and more demanding burden on majority group plaintiffs. So I don't think it's consistent with this court's precedents.
So Mr. Wang doesn't think the Sixth Circuit decision followed Supreme Court precedent by adding the greater burden to majority group plaintiffs. Next, Chief Justice Roberts puts the question in another context.
What if you have a situation where, say, 60 employees in the company, say, a half dozen African Americans? An African American applies for a job. There's an opening. He doesn't get it. Remains open for, a couple of months. Does that satisfy the prima facie case? If he said it was because of discrimination.
Assuming that they are qualified and yes.
Okay. Now, I'm sorry. That's a yes?
Yes, that is true.
Okay. Now let's say it's the same thing, but the applicant is white. Exactly the same facts. And she says, I lost the job because of discrimination on the basis of race. Does that state a prima facie case?
I think it states a prima facie case, but I think it goes, and perhaps, Your Honor, it goes to the idea of getting employers to come forward with an explanation and then providing sort of a legitimate non-discriminatory reason, which I don't think is a high burden at all. I think as Reeves, as Burdine, as Fernco make clear, they just have to provide some sort of legitimate non-discriminatory reason to answer or to rebut the prima facie case.
So what appears to be an obvious case of discrimination can be stopped if the employer simply shows there was a non-discriminatory reason for the action. Justice Barrett dealt with a claim that, should the court agree with the petitioner, it would open almost any case where someone did not get a job to claims of discrimination.
Counsel, what do you have to say to the department's contention that this is just going to throw the door wide open to Title VII suits? Because now everybody can say, hey, this was discrimination on the basis of race, gender, et cetera.
Well, I don't think that contention is well taken, Justice Barrett, and for two reasons. The first is this is an evidentiary question that arises at summary judgment. So they've already gotten past a discussion with the EEOC, plausibility under Iqbal and Twombly, a motion to dismiss. So I think if there were a floodgate issue, that would be sort of more on the pleading standards. I think the second point is merely sort of an empirical question. And as we lay out, and as Judge Kethledge lays out in his concurrence, about more than half the circuits don't apply the background circumstances rule. We don't see those circuits having some sort of flood of litigation. I don't think there's a huge delta between those circuits that apply it and those circuits that don't apply it, which I think goes to the narrow question that's before the court today.
Other circuits do not use the background circumstances rule, and they do not have a problem. Neither does the EEOC. So there's no reason to believe removing the rule from all circuits would make much of a difference. Now, Justice Kavanaugh wanted to know what Mr. Wang wanted from the court.
So all you want for this case is a really short opinion that says discrimination on the basis of sexual orientation, whether it's because you're gay or because you're straight, is prohibited and the rules are the same, whichever way that goes.
That's right, Your Honor. And
that's all we need to say, right?
I think that would be something. Well, I think you'd also have to say reverse or vacate and remand. I want to look out for my client here a little bit. But certainly as to the reasoning, yes, I entirely agree. I think that this is a narrow question, and it's a question of, is there an added burden? And if the answer, I think, under McDonnell and under Title VII's text is no, then this goes back to the lower courts to resolve.
A simple ask of the court. Make sure that every case before the court is treated the same, regardless of whether they are part of some protected class or not.